Nova Scotia v. Walsh, 2002. Summary. Susan Walsh and Wayne Bona lived in a common law relationship for approximately 10 years. Walsh and Bona had 2 children together who continued to live with Walsh after the relationship ended in 1995. After the relationship ended, Walsh requested child and spousal support from Bona. Walsh also challenged the charter on the grounds that the term spouse in the Matrimonial Property Act, MPA, should include common law couples. Walsh claimed that since common law relationships and marriages were so similar, excluding common law couples from the definition of spouse under the MPA was a violation of her human dignity and therefore unconstitutional. Analogous grounds and enumerated grounds. These are terms that are used quite often throughout the presentation. An analogous ground refers to distinctive features or characteristics of an individual that can be lawfully discriminated against. Analogous grounds are characteristics that are not included in the list of enumerated grounds. Examples of analogous grounds include marital status, sexual orientation, and citizenship. Since marital status is an analogous ground, the court should rule that the definition of spouse in the MPA is lawful. Enumerated grounds. An enumerated ground refers to specific features or characteristics of an individual that cannot be discriminated against. There are 9 enumerated grounds outlined in Section 15.1 of the Canadian Charter of Rights and Freedoms. The enumerated grounds include race, national or ethnic origin, color, sex, age, and mental or physical disability. Any laws or regulations that discriminate against an individual based on an enumerated ground would violate Section 15.1. Walsh's arguments. Walsh argued that she was entitled to both child support and spousal support at the end of her 10-year common law relationship with Wayne Bona. Walsh brought forward a charter challenge challenging the term spouse in the MPA. The term spouse was limited to married couples in the MPA. Walsh argued that the term should be extended to include common law couples. Walsh argued that excluding common law couples from the definition of spouse violated her human dignity. Relevant acts and laws. Constitutional law. The Constitution Act of 1982 includes acts and legislations implemented to protect Canadians. The Constitution Act includes the Canadian Charter of Rights and Freedoms and the protection of Indigenous and other Canadians' rights. Furthermore, the Constitution is the supreme law of Canada and can only be altered through the courts or through official legislation. The Law Reform Act of Nova Scotia of 2000. The Law Reform Act of 2000 was enacted in 2000 by the provincial government of Nova Scotia. The act was enacted to obey certain court orders and ultimately modernize and reform outdated laws in their province. The Matrimonial Property Act of Nova Scotia. The Matrimonial Property Act of 1980 governs the distribution of assets for individuals who divorced prior to January 1st, 2020. As of January 2020, the Family Property Act has replaced the Matrimonial Property Act. Relevant acts and legislation. The Matrimonial Property Act is an act that outlines how assets should be distributed in the result of a divorce or if an individual's spouse passes away. In Nova Scotia v. Walsh, Walsh is attempting to change the definition of spouse to include common law relationships in hopes of receiving remedy from their separation. Section 15.1 of the Canadian Charter of Rights and Freedoms states that every individual is equal before and under the law and has the right to equal protection and equal benefit of the law, without discrimination and, in particular, without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. In Nova Scotia v. Walsh, Walsh claims that she is discriminated against since the Matrimonial Property Act's definition of spouse does not include common law couples. Trial outcomes. The trial judge ruled that the definition of spouse was not discriminatory by excluding common law relationships under Section 15.1 of the Canadian Charter of Rights and Freedoms. Walsh successfully appealed the case to the Nova Scotia Court of Appeal. However, the Nova Scotia provincial government appealed to the Supreme Court of Canada. The Supreme Court of Canada had to consider 2 constitutional questions. The first, whether or not the exclusion of common law relationships in the definition of spouse was discriminatory under Section 15.1 of the Canadian Charter of Rights and Freedoms. If the court found the exclusion of common law relationships discriminatory and a violation of Section 15.1 of the Charter, the court would have to rule if the violation could be justified in a free and democratic society, as stated under Section 1 of the Charter. Supreme Court of Canada ruling. Writing for the 7 judges of the Supreme Court of Canada who presided the case, Justice Bastarash ruled that excluding common law couples or couples who are not married from the definition of spouse in the Matrimonial Property Act was not discriminatory. Justice Bastarash applied the 3-part test created by the Supreme Court of Canada justices who presided Law v. Canada, Ministry of Employment and Immigration, 1999, to determine that there was no discrimination under Section 15.1 of the Canadian Charter of Rights and Freedoms. The court determined that the first 2 parts of the test were met due to the fact that the court recognized that common law couples received different treatment as a consequence of the MPA. The court ruled that marital status was an analogous ground. The court then had to determine whether the differential treatment of married couples and unmarried couples under the MPA was discriminatory. Justice Bastarash asked the court whether a reasonable heterosexual unmarried cohabiting person, taking into account all relevant contextual factors, would find the MPA's failure to include them in its ambit has the effect of demeaning their dignity. In their ruling, the majority of the judges emphasized marriage and how marriage is a choice. The judges ruled that since those who wish to get married can do so freely, it is their choice whether or not to have the MPA applied to their relationship, and therefore was not discriminatory. The dissenting opinion. Justice Lerdoux did not agree with the majority of the judges and wrote a dissenting opinion. Justice Lerdoux stated that the definition of spouse in the MPA was discriminatory since common law relationships and marriages were very similar, and both relationships face similar economic challenges if the relationship ends. She stated that the intention of the MPA was to ensure citizens were not disadvantaged for being married. Furthermore, the MPA upholds and establishes rights for individuals who are or have been divorced and ensures both parties can afford to live. They claim that the term spouse in the MPA should include common law couples, as common law relationships are becoming increasingly common, and stated it would serve the same purpose for common law couples as it does for marriages. Relevant cases and similar cases. Miron v. Trudel of 1995. Miron was in a common law relationship with the mother of his children. After a car accident left Miron disabled in 1987, he was unable to work. Miron was denied a claim from his spouse's insurance since they were not legally married, even though it included spouses. The court determined the conditions of the insurance policy and the exclusion of common law relationships from the term spouse was discriminatory towards individuals in common law relationships. And Hodge v. Canada, the Ministry of Human Resources Department. Hodge was in a common law relationship for several years before it ended. After her former spouse passed away, Hodge was seeking access to his benefits from the Canadian Pension Plan. However, since they were not married, Hodge was denied access. Hodge claimed that she was discriminated against based on Section 15.1 of the Canadian Charter of Rights and Freedoms. The Supreme Court of Canada found that since Hodge was never married, and they were not in a relationship at the time of his death, they were not spouses in the eyes of the law. Therefore, Hodge was denied access to his benefits. Whether or not to marry. Is it always a choice? The judges for the Supreme Court of Canada who presided Walsh v. Nova Scotia emphasized the choice of marriage in their decision. The majority ruled that since anyone can choose whether or not to get married, they can choose whether or not the MPA applied to their relationship. While individuals can choose to marry, many would argue marriage is not always that simple. There are many relationships in which one of the parties wants to get married, but the other does not. This is an instance in which an individual may not be able to choose to get married. Although there are alternate cost-effective options to get married. Some individuals may be living paycheck to paycheck and may not be able to afford any ceremony, even one without guests. Religious individuals may not be able to get married due to their religion. The presiding judges for this case: Justice McLaughlin, Justice Luer Douay, Justice Gautier, Justice Benny, Justice Major, Justice Iokobuchi, Justice Bastarash, Justice Arbour, and Justice LaBelle. Justice Beverly McLaughlin was appointed to the Supreme Court of Canada in April of 1989. Justice McLaughlin was appointed the Chief Justice of Canada on January 7, 2000, and held that position until she retired on December 15, 2017. The Honourable Claire Luer-Dubé is a retired judge of the Supreme Court of Canada. She was appointed to the Supreme Court of Canada on April 15, 1987, and retired on July 1, 2002. The Honourable Charles Doherty Gautier was appointed to the Supreme Court of Canada on February 1, 1989. Justice Gautier served as a judge for the Supreme Court of Canada from 1989 to 2003. Unfortunately, Justice Gautier passed away on July 1, 2009. The Honourable William Ian Binney was appointed to the Supreme Court of Canada on January 8th of 1998. Justice Binney retired on October 21, 2011. The Honourable John Major was appointed to the Supreme Court of Canada on November 13, 1992. Justice Major ultimately retired on Christmas Day of 2005. The Honourable Iokobuchi was appointed to the Supreme Court of Canada on January 7, 1991. Justice Iokobuchi retired on July 1st of 2004. The Honourable Michael Bastarash was appointed to the Supreme Court of Canada on September 30th, 1997. Justice Bastarash served on the Supreme Court of Canada until his retirement on July 1st of 2008. The Honourable Louise Arbour was appointed to the Supreme Court of Canada on September 15th of 1999. Justice Arbour presided on the Supreme Court of Canada from 1999 to 2004, when she retired on July 1st of 2004. The Honourable Louis LaBelle was appointed to the Supreme Court of Canada on January 7th of 2000. Justice LaBelle retired on November 30th of 2014 and unfortunately passed away earlier this year on June 8th of 2023. Conclusion. Nova Scotia v. Walsh is a controversial court case regarding the definition of spouse with respect to the Matrimonial Property Act in Nova Scotia. Walsh believed she was entitled to spousal support and child support after their common law relationship ended. However, the Matrimonial Property Act, which assists couples at the end of marriages with the separation of their assets, defines spouse as married couples. Walsh claimed it was unconstitutional for common law couples to be excluded from the term spouse. Overall, the Supreme Court of Canada found that since any and everyone is free to get married, the MPA was not discriminatory.